Thank you all so much for jumping on. Feels kind of funny to see familiar names and not be able to see faces, but thank you all for your time. As most of you know, I'm Liz, and Margie is on the screen too, I believe. I don't know if it shows both of our faces at the same time or just one, but either way, this has been an ongoing subject and something that we feel strongly about. So we thought a good way to just kind of get the basic information out there would be to do a webinar. So it just based on the turnout, it is definitely a topic of interest. So our biggest disclaimer is, as you all know, we are financial planners, not estate planning attorneys. So we by no means are professing to be the professionals on this subject, but it is really important to a comprehensive, holistic, sound financial plan to have your estate plan in order. So we feel strongly about it and we wanted to bring it to you today. Anything to add, Margie?
Well, just that we work a lot with the estate planning attorney. I think twice even today in one day, I've had to reach out to the estate planning attorney for various reasons. So it's a team effort, and Liz nailed it before. Attorneys have their professional way of doing things. We have our way. The accountant has their way, but really it's a three-prong approach in helping you all. And again, thanks for being here.
Yes. All right, so we'll just jump in. We want to be sensitive to everybody's time, but basically estate planning in a nutshell. So estate planning is going to designate who's going to receive your assets and handle your responsibilities after death or incapacitation. So I think it's really important to just remember that your estate plan is not just for after you are gone, but it's also for the God forbid you can't make your own decision scenario. You know, God forbid you have a stroke and you're laying in a bed and unable to communicate, you know, who do you trust and who do you want to make your decisions at that point? Make sure beneficiaries receive your assets in the most cost-effective way possible. And we're going to talk a lot about that. Again, not being experts, and it does vary state to state, but really understanding what you need to do on your part to make this a clean transition at whatever point that happens.
Yeah, I will interject in here if I may, Liz, sorry.
Sure.
But
No.
it just brings to mind a recent case that I've heard about where the estate planning was not completed, and the cost to that estate for having the attorney handle most everything, because decisions just were not made, cost tens of thousands of dollars, as opposed to the cost that it would have been had decisions been made and the estate planning documents be put in place.
Yes, definitely. I mean, we can all probably just even get on Google and find some scary stories. But I think the biggest thing that Margie and I see a lot of times is this fear of, I'm not sure exactly how to make this work. What we always say is it's kind of like your financial plan. Having an estate plan in place is just, you kind of lay that foundation. You can always fine tune it. Life, as we all well know, will throw us curveballs. So just because you get your estate plan in place doesn't mean you can't change it down the line. The other thing too, you know, having Margie's married to an attorney, so she lives this every day, but having run through our own personal estate plans, the biggest thing we can say is just have an idea of what your goals are. You know, I want to make sure that if I pass away, my assets go to my husband, and then God forbid we both go, that our children are taken care of. So again, making sure that you really just verbalize what is your perfect picture. You don't have to come up with how do we get there. And the attorney, you know, 9 times out of 10 is really going to be able to help walk you through some questions that maybe you've never thought about, and also shed some light on, you know, how do we get to where you want to go. So again, just keep in mind that it's not set in stone. It's just kind of this foundation. You can always modify it, but better to have something in place. If you're kind of wishy-washy and you're not 100% certain, still get something in place. And then if you change your mind or your situation changes down the line, you can certainly go back and revise it. 6 things to know about estate planning. I think this first one is so important. Be aware of probate. So just be sure here, it does not say beware. It's not like probate, I think sometimes can get tainted as this awful thing. It's not necessarily, but you want to understand how the process works and how you can help facilitate it. Create a will. That is, step number one. Decide on beneficiaries of your assets. Consider creating a revocable trust. Consider having a power of attorney drawn up. This is where Marge and I are saying, number 5 is, I think, our ongoing conversation of making sure that whoever needs that power of attorney, whoever is that power of attorney, we as financial advisor, if God forbid you could not make a decision, we would rather have that power of attorney and not need it than need it and not have it. And unfortunately, as Margie often says, one time of this happening is too many. And we've seen that happen, whether it's, again, a stroke or a rapid decline of dementia or who knows what, but life can throw curveballs. Get that stuff put in place before you need it. Have the talk, having that conversation. I'll pick on my dear grandmother that I love so much, but she just never wants to even think about herself not being Miss Independent and having everything taken care of. And so it's really been, I'll say, literally years in the making of being able to have a conversation of, what do you want? Make sure your family understands, do you want to be kept alive as a vegetable? Do you want to just say, no, that's not my choice? Or do you say, hey, if I have a fighting chance, I really want that fighting chance. Have the conversation with your loved ones or with a trusted person while you can kind of laugh about it. Again, before you're backed into a corner. I just talked to some dear clients this morning, and it's, no real estate planning was done. The mom is, for the most part, not really mentally, she doesn't have any memory. She can have the same conversation 20 times in a day, and it brings her a lot of joy. Thankfully, she's still happy, but she doesn't have any memory. So, to have that discussion at that point is impossible. So have the conversation, really give your family, take some of that guessing work out of it for them. So be aware of probate. So probate is basically the process that the court is using to settle an estate. Settlement time and expenses vary by state and situation. So again, what goes through probate and more importantly, how it goes through probate can really dictate how those expenses add up. And we're going to touch on it next, but the will, actually, I'll just jump right over to it. So the will is really kind of this roadmap for the court system. So again, going back to having that conversation, having the will in place, who do you want to handle your affairs? Where do you want your money to go? For somebody that Margie just referenced, if there's literally nothing in place, then it's this guessing game done by the court system. A lot of time, a lot of energy, a lot of guessing, a lot more money goes along with it. And not to mention, family stress in the midst of a time of grief. So that will is basically a roadmap for the probate system. Even if you didn't have beneficiaries on a thing, at least it gives them guidance of where do you want your assets to go. It doesn't avoid probate, but again, it takes the time and energy and the guesswork out of it. I think this is a really important one to highlight too. It can help eliminate any potential family disputes. So, having it in writing, again, I think I used my husband before, but he was the executor for his grandmother, and he recorded, they had the talk while she was still relatively coherent, and he recorded the whole thing so that way there's just no questions. We all, I come from a very tight-knit family. I know a lot of folks we work with are extremely tight-knit families, which is wonderful, but to take that stress, death and finances can bring an extreme amount of stress. So just to eliminate any questions and make it very clear what your wishes are is so important and such a gift to your beneficiaries. Making sure all of your assets have beneficiaries formally named in other documents. So again, skipping over to actual beneficiaries, assets with a named beneficiary avoid probate. I think that's really important to highlight. So for the bulk of the assets that we are helping to manage, think IRA, Roth IRA, those we're consistently doing beneficiary reviews and making sure, is this up to date? Is this who you want to have listed? Do you have a contingent beneficiary? So again, you know, if my husband is listed as my beneficiary on my retirement plan, God forbid we get in the car together and there's no contingent on there, then it goes back into probate and kind of a guessing game if I don't have my estate plan in order. So making sure that you have assets, named beneficiaries, again, IRAs, 401ks, insurance policies are all big ones. Don't forget about everyday assets. So your checking account, your savings, those are sometimes referred to payable on death. Even the state of Maryland, oh, sorry, let me go back. Got ahead of myself. I believe now you can put a beneficiary even on something like your car, the MVA.
You can. There's actually a motor vehicle administration link that you can create a beneficiary on a vehicle.
So it's like 20 or 25 bucks or something, right?
Yeah, it's reasonable, and it's only been recent. So it's, again, one of those other areas. And so Liz touched on POD is often used with banks, credit union assets. TOD, transfer on death, that's used for non-retirement assets. So they're all beneficiary names that go on there. It's just some different terminology. But once again, you just want to make sure that you conduct a review or have us go through the review. It happens time and time again, and sometimes changes do take place.
Absolutely. And on the same note, going back to having the beneficiary in place, just reminding you again, those beneficiaries are going to supersede anything that's in your will. So it's going to avoid probate and it's going to supersede the will. So for example, I just was working with my grandmother on some of this stuff, trying to finally get her to turn the corner and do some of this. And they referenced her will from 1986. And I just had to laugh because I'm sure that none of the assets that she has today were even listed in the will in 1986. So again, making sure that the beneficiaries really will help you to avoid some of those costs that are associated with probate. And usually it's probably a simpler process to update those beneficiaries is my guess.
And Liz, before you switch, beneficiaries, are you going to get into pro rata and per stirpes, or would you like me to jump in?
Go for it.
Okay, so back to the IRA, 401k, TOD, POD, there's in some cases a further option, and that is to choose either pro rata or per stirpes. So here's my little word association trick, per stirpes. Not like that's going to necessarily stick, but I think of it as stripes, close enough in spelling, and I think of it as linear. So if someone is named as a per stirpes beneficiary, they pass away before change takes place on the beneficiary form. That means that that individual's assets would go into that next line, that, let's say, a child, as opposed to pro rata, which means 2 or 3 beneficiaries may be named, a third, or 50-50. One passes away before any change takes place on a beneficiary form, any updates. That deceased person's portion would go to the remaining living beneficiaries. So pro rata, per stirpes, TOD, POD, beneficiaries, all important vocabulary words.
I'm going to give an example. I'm much better with examples, and I'm going to go back to my grandmother. So my grandmother has 4 daughters. My grandfather is no longer with us. So the 4 daughters are 25% beneficiaries on everything for my grandmother. If, let's just say, my mom passed away and my grandmother never changed her beneficiaries and still had them all listed as the 4 girls, and then my grandmother passes away, if it was pro rata, then my mom's 25% would filter to the other 3 sisters, and it would be 33, and it would be split evenly between the remaining 3 sisters. If it was per stirpes, so again, think that stripe that Margie referenced, then my mom's 25% would pass down her lineage through her estate plan, which is not done, and be split between her 3 children. So that is, I think, again, I'm just more of a visual learner, I think. Hopefully that helps.
And we can get stuck on these. We want to be sensitive to time, but the slide is making me think of this question that comes up sometimes. in naming children as beneficiaries. If you name a child who's not yet has not reached the age of maturity, 18 in some states, 21 in other states, you know, those assets could go in that direction, but they're not old enough to manage. So a custodial parent, for example, would have to manage those assets. It gets a little more convoluted, so be careful in naming minor children.
And I'm going to get off subject even further and talk about, so again, Margie and I are in a little bit different life stages. You know, I have a 3-year-old and Margie's sending her youngest off to college in the fall. But just because we're talking about estate planning, and oftentimes people think estate planning, death, dying, all of those things, it is so important for my generation, or, you know, anybody who's young, especially with young children, to have a sound estate plan in place. Number one priority is for those minor children. So to Margie's point, let's just say, you know, you have a handshake agreement with your brother and sister-in-law that they're going to watch your children, God forbid you and your husband die. And then you have your husband listed on as your beneficiary, your children as your contingents. If you die, it's still up to the court system. Even though you might have that handshake agreement, they still have to go through the probate process and all of that to determine guardianship. You know, they might have verbal, you might have something written, but if it's not officially on, you know, documented, then they still have to go through that process, in which time, who knows where your kids are and how they're being taken care of. And then also, you know, maybe that guardian is one person, but maybe who you trust to be the financial custodian of those assets until your children are age of majority is different. So really outlining that and having backups too. You know, again, I think death is a big time of grief. So you want to make sure that if my brother says, I'm just not in a place where this is going to work, you want to have a second backup picked and not leave that to the court system too. So it's not just for the older generation, we'll say. Estate planning is for everybody. Golden rule of estate planning, kind of on the same note. Sorry, I'm trying to move our faces. Make sure you always update the beneficiaries. And again, we will try our best to always keep on top of this. I just had a review, and I was talking to a client whose husband passed away in 2014, believe it or not, and she found an old annuity. And I said, have you checked that beneficiary? And sure enough, it's her deceased husband. So just making sure, birth. So if you have another child, death, husband, wife, whoever passes away, you want to go through and update them. Marriage is a big one. I'm a culprit. I just looked at something where I didn't have my husband listed. So obviously I need to change that. Divorce, another big one. Just again, any big life changes, you want to make sure that you have those up to date. Making sure your beneficiary designations are up to date, even on things like, again, cars, boats, and valuables. So let's say you get a big family heirloom passed down to you. I don't know what that would be. Let's say a piece of jewelry. You know, you can even be so specific in your will to list things like the jewelry. Again, you can go to the DMV if you're in Maryland or MVA and list a beneficiary on your car. But just making sure that you have it across the board on all your big assets is really important, and keeping them up to date. All right, we are not accountants and we are not estate planning attorneys, but this is so common. You know, normally folks' biggest assets are going to be their primary residence, especially in a world like we live today with this crazy real estate market, and their retirement assets. But how they are handled as it stands today are very different from a tax perspective. So real estate, your primary residence, I just had this conversation again earlier today where this client just bought a house and she's like, yeah, I'm just going to put my daughter on the deed. And I explained, if your kids are on the existing deed, then their cost basis is your cost basis. Versus if they are listed as beneficiary on the real estate, then they can receive a step up in basis. So if you bought your house for $100,000 and when you pass away, it's worth $400,000 and they decide to sell it, that $400,000 is tax free to them versus paying taxes on the $300,000. So again, real estate as it stands today can receive a step up in basis so long as it's passed at death and not prior. Heirs can avoid the capital gains taxes. IRA or 401k are dramatically different. massive changes. Was it, oh my Lord, I've lost track, 2020 or 2019?
End of 2019. 2020 was a lost year.
Yeah. So in 2019, prior to 2019, if you left money in a pre-tax IRA to kids, or next generation, we'll say, take spouse out of it, then they could stretch those distributions over their lifetime. So let's just say, so I can do the math, if you left $1 million in a retirement asset, your kids could take that money out over time, pay taxes on the little bit they're required to take out, but they don't have to pay taxes on the whole thing right away. Now, anybody who passes away in 2020 or beyond, that pre-tax, and even a Roth IRA, has to be liquidated on the pre-tax side. You have to pay taxes on it all within 10 years. So again, go back to that $1 million scenario, $1 million has to come out and taxes have to be paid on it within a 10-year period. So really different between your primary residence and your retirement plans. And strategizing, I know we could get into the weeds on this, but we really do try hard to strategize with you on, what's your long-term goal? Obviously, priority number one is making sure you don't run out of money. But when you pass away, let's really figure out how do we have the most impact to your beneficiaries in a good way, and how do we strategize and make sure you're set up for that. And these days,
I'm going to interrupt for a quick second.
Yeah.
My apologies. And because it even came up today, and folks are all over the board on how they think that their assets should pass on, whether the beneficiaries should be the ones that handle the taxes, because after all, they're receiving this huge gift. Why should the owner, this is just one train of thought, incur more taxes? Whatever the kids get or non-spouse beneficiaries get, then let the tax burden fall on them. Liz just mentioned strategies. It's our job to share with you strategies. At the end of the day, the decision is, of course, yours. It's your money. But part of that strategy may be how we can help alleviate some of what that next generation would be getting in terms of the big old tax bill, especially in light of this Secure Act change that Liz is talking about. So there's not one right answer. It's just us sharing with you the different options. And at the end of the day, you're making a decision.
And one other thing that we just like to kind of share what we see out there. I'll say we often will hear, well, I'll just leave it to my eldest or, whichever child, and they'll make sure everything gets divided appropriately. I trust them. My kids are close. It's all fine. But if you do that with something like an IRA, especially, so again, let's say you have 3 kids, everything's supposed to go equally to the 3 kids, but you just say, okay, I'm going to let my eldest be in charge of all of this. Well, in that IRA case scenario, all of that $1 million tax burden would fall to them. It would be very difficult, almost nearly impossible for them to filter that money to the remaining siblings. So again, it's really important that you list exactly who you want on the beneficiary forms, not just in the will, so that it's divided equally and the tax burden is not landing on one person more than another.
Yeah, that was a good one. That has come up numerous times. I think even my own dad had that. Well, you can take care of this brother because he's not so financially savvy. I'm like, hold on.
And taking that one step further, in that scenario, let's say you have 2 kids that are very financially savvy and one that just doesn't understand how a credit card works, for example. And you just say, I can't have this 25 or 35-year-old get a big inflow of money. Well, then you could list the 2 kids that are fine as direct beneficiaries, and then maybe the 3rd beneficiary is some sort of trust that stretches how, that dictates how the money goes to that person. Another good scenario would be a special needs trust. If you have a child who will likely be financially dependent on you for all of your life, that special needs trust is so, so, so important. And that's where, again, the attorney can step in and work.
It's a great segue to the next slide.
Oh, good. Sorry if I stepped on your toes there.
It's all good. We're jumping right into trust, and that is, as I said, a great segue. I'm going to step on Liz's toes here a minute and just again say, yes, there's special needs trust, and there are trusts that can be named as a beneficiary. That's where it gets very, very important to be working with an estate planning attorney. LegalZoom is not going to be able to answer to. I would be very reticent in do it your own DIY on those sophisticated, well, any of this, quite honestly, and bring in the professional. And so let's talk about trust for a minute here. This was 4 out of the 6, and creating a revocable trust. You may have heard the term living trust. They're synonymous. As the bullet 2 here says, it's for larger physical assets, but I'm going to mention that other things can go into this trust. Even a business could be in a trust. Assets, non-retirement. Liz talked about it before we went on about the beneficiaries of non-retirement and retirement, but having assets, stocks, bonds, mutual funds held in a trust. It is on that 3rd bullet there, naming trustees to make decisions. I can have my own trust. I can also be my own trustee. We could have a family trust, my husband and I, and again, he and I can both be trustees. And then having successor trustees if something happens to one of us. We're going to go a little deeper on this in a minute, but what we're looking to accomplish here is back to, okay, avoiding probate where we can. And the reason to avoid probate, it's not going to save us on taxes, and it's not going to, it's still stipulating like a will does, but it makes for the ease of the transfer of assets. It has been spelled out in that trust document. So trustees are making decisions. Now, what happens if one of the owners dies? We'll talk about in just a second here, but a smoother transition, that's what a trust is setting out to accomplish. And it has assets in it, unlike a will, which is that roadmap. Personally, I would move the power of attorney up to the 1st instead of the 5th on our list of 6 things. And Liz and I, once again, we're sharing with you what we've seen and how things can flow smoothly. Unfortunately, we have had occurrences where power of attorney becomes necessary. We have, unfortunately, had to help through as best we can where there is no power of attorney that was put in place. And there was, from our perspective, this is where we're documenting on our side, spoke to the Jones family, the Smith family, about getting their estate plan in place. As need be, there's some attorneys we work with, that's a question we get, or talk to family members, friends to come up with a name. Don't let that stop you from taking care of these very, very important documents. So let's go ahead on the next slide and talk about durable power of attorney. So there's some vocabulary in here, okay? Your agent is your power of attorney, who you are giving that power to transact a lot of different things. Now, back in the day, pre-COVID, maybe even before, documents had to be signed. I'm thinking of, going to settlement documents. You had to be there and do a wet signature, as we called it. Well, if you're out of town, sometimes there would be an assignment of power of attorney if you couldn't make it to a settlement. So okay, fine. But these other financial transactions, it's getting ahead of the curve before it becomes necessary. So making sure, yes, absolutely, it needs to be a trusted person. Now, from our standpoint, these are some of the questions we get. Okay, well, does that mean that Susie can call Blue Heron Financial Group and request tens of thousands of dollars to be sent out? You have assigned that trust. They have a power of attorney. We have that power of attorney in place. Now, we know you. We're also going to make that phone call to say, was this your intention? And that second bullet there, it's revocable. So if Susie called the office and started requesting money, guess what? Number one, we would hope to put a stop to that real fast. And number two, there is the revocability, if that's a word, to change it. So this is not set in stone. There used to be irrevocable trusts that were used for some reasons back in the day. And I, on 2 occasions, had a client tell me that their attorney suggested they put their home in an irrevocable trust. Now, maybe there was some basis for that, but knowing their situation, that they may want to eventually move and sell, it didn't make sense. So irrevocable, very difficult to change. That's not what we're talking about. Trusted person. If your spouse, maybe that spouse is not at all geared on financial matters, then maybe it's a matter of bringing in an adult child or another family member. So the big one here is going to be a trusted person.
And I think just to add here too, just because you're married, let's say the husband was the breadwinner, he worked a lot of years, the majority of the assets are in his name because they're retirement assets, and the wife was a homemaker. You know, just because you're married does not give you power of attorney. It still has to be a legal document. So even if you say, no, my spouse is who I want to make my financial decisions and my healthcare decisions, if I can't, then it still needs to be a legal document stating that. And I could be totally wrong here, and this is why we defer to the attorneys, but I believe that with a financial power of attorney, Margie, don't you think that you can put it in place while you're of sound mind, but say that it doesn't kick in until a doctor says that you can't make your decisions? Is that possible?
There are some caveats. I did run that by my husband. But here comes the issue with that is, you know, how long is it hung up before you know, I mean, how quick is your doctor's? Are they getting back to you? And you know,
True.
So it can hang things up. But when we think of what can happen if there's not a power of attorney in place, yeah, holy smokes, that can be a real issue. Unfortunately, again, we've had that occurrence where it's not in place, and then there has to be an assignment from the courts of guardianship. That's a painful experience, painful and expensive. That's what we're trying to help you avoid here.
Mm-hmm.
So let's talk about the other very important power of attorney, and that's called a healthcare power of attorney, healthcare directive. Many go into the hospital and they've got to sign off on the hospital's document. And I'll share, this is a story my husband brought up, shared with me as I ran by some of the estate planning seminar. And he said, you know, you got to be a little careful in this DNR thing, because if according to, you know, they're unfortunately, you know, go through surgery and have a problem, a quick problem, and there's a DNR, do not resuscitate on there. Well, what if it's something that they could have fixed? They could have, you know, I don't know, done that heart thumper thing, or, you know, injected something. I'm not medical, I don't know. But the point is, having the healthcare power of attorney in place is going to be a lot more detailed. When to resuscitate, when not to resuscitate, and gets into a lot of details. Liz said it before, I'll say it again. Much easier to go through and take care of these things before necessity. I know I updated mine recently. I still went in with, you know, a sense of humor. I'm like, you know what? Keep me comfortable. Keep me comfortable. But then other things like, you know, do you want a feeding tube? Do you not want a feeding tube? Let's see if this can show up on the screen. This is called 5 wishes, if you can see that. So first of all, we hope that you will seek out an attorney and get these documents in place. They're so important. But take a look at 5 wishes. You just Google it. I Googled it before the presentation today one more time. Gets into a lot of detail. It's $5. And I'm not saying that should take the place, but at least it gets your head thinking about how to complete such information. You can use it. It's a legal document in something like 42 states, I think. But it has those different areas, like how comfortable do I want to be? How do I want people to treat me? What I want my loved ones to know. And that's what I mean about going into more detail. So getting your healthcare power of attorney, healthcare directive in place before necessity.
And not the
Backup agent was that last one on there. You know, heaven forbid, one of the kids can't be located, they're hiking the Appalachian Trail or something, then having that backup is going to be important. One other item comes to mind. I did some work with the foundation at our hospital here in Anne Arundel County. They had a palliative nurse care come in, and the suggestion from her, and she's frontline, was, you know, don't name all your kids as equal healthcare power of attorney. Some may say pull the plug, and the others may say keep her going forever and ever and ever, and having, you know, really that one with a backup, and choosing that person who will follow your decisions and shares your views. Anything else, Liz, you want to add on?
I was going to say, I mean, I love that point from the palliative nurse. That's really good. But I also know for my dad's mother, it was either, like, she had 4 kids, 3 of which were local, but she made it so that on the financial power of attorney, it could be any of them, but it didn't have to be all of them agreeing. You know, so I think that's important too. Again, if you can't find somebody, any of the 3 could sign. It doesn't have to be 3 agreements on the financial side. I think is helpful.
Okay, so having the talk, Liz talked about the talk, and I'm talking about the talk, and this is, you know, just getting that conversation open. I kind of sometimes think it's generational, where our parents and their parents maybe kept a lot of these things closer to the chest, a lot more privacy. And as we go down through the generations, there's a lot more open discussion. I could be wrong on that, but I'm just feeling that might be going on. It is difficult sometimes to open that conversation. I'm very thankful that my parents have had put in place a lot of all of this that we're talking about. It really takes the weight off of my and my brother's shoulders when we will be in a period of grieving. And I think that's very important, to have to rush into decisions. Why not get it all taken care of before it's an emergency situation? So yes, having the conversation with aging parents and relatives. Liz talked about it earlier, but I'll bring it up again, but also for young people. Young people are building their 401k plans. They have kids, perhaps. There may be life insurance policies. Where are the assets going, and how should they be treated? And just avoiding postponing the talk.
And just to touch on that, this is not part of the seminar at all, but if you have young kids, Margie touched on life insurance. Life insurance is a must. Again, you think about your income and multiply that by 20 years, you know, that's your income ability without any raises, without any inflation. You know, your income is really your biggest asset to your family while you're raising a family, because it's going to be what pays down the mortgages and saves for college and saves for retirement. So protecting that with life insurance, that God forbid you're not here. And even if you have a stay-at-home parent, you know, their role, I can tell you, I pay childcare. It's not a small amount of money. And so making sure that just because that person doesn't have an income coming into the household, there still needs to be protection there, because if they're not here, you're really going to have to, you'd either have to give up income on your side, or you'd have to pay somebody to help out, probably a combination of both.
We're going to go back and just touch on the living trust just a little bit more here, because they truly are becoming more popular. We spelled out before, it doesn't take the place of a will. It does not necessarily, again, probate is not a bad word, it's not, but if we can get a lot of the structure down ahead of time, then it's going to save time and money. And getting the court involved can be a time-consuming and expensive proposition that's not necessary. Flexible many, many, many times, beneficiaries are changed. Within a trust, the designation of where you want assets to go can be changed. Over time, perhaps assets are accumulating and are at a higher level than where they were 20 years ago. So revisiting those documents, many, many times, Liz and I will have this conversation with clients. They're like, yes, I did something 25 years ago when the kids were minors and now they have kids of their own. Okay, it's important to go back and take a look and see, really, do you still have it as it should be? So a trust can hold assets, it can designate where they go. You can be very, very specific. Just talk to Wayne about this, on how those trust assets are paid out. Now, he did mention that if the income is not paid out, there's some tax ramifications in some respects. But let's say that you want to have some control and not hand over a lot of money to a young person for a variety of reasons. One, you may be concerned about them spending down. Two, you may be concerned that they will not take the responsible route and get that job and further their career and become productive members of society. There's a lot of different reasons. Special needs trust, another one. I do have a brother who has some, I don't think handicaps is the right word anymore, but anyway, so he needs some assistance. So his assets would go into a trust, and I can help out with that. But bottom line here, there's flexibility, and what it does help is to spell out how those assets should be passed on.
So the attorney will help you set up the trust, help you determine, number one, is that something that is suitable for you? And then number two, get it set up. The third step is probably one of the most important, and sometimes what falls off is actually funding the trust. So let's say you work with an attorney, you all agree collectively that, having this revocable or living trust makes sense for you. They create the trust, then you need to retitle assets. And again, Margie touched on this. We are not experts. They usually dictate, hey, you have a non-retirement account. That non-retirement account, instead of being transfer on death with beneficiaries listed, is now retitled in the name of the trust. Your home, cars, bank accounts. So that is a very important step. If you go the direction of a living trust, then you need to make sure that you follow through and everything that's technically supposed to be in that trust is in the trust. Because if you have the trust and there's nothing in it, then it doesn't do anything when you pass.
Exactly. Okay, so I think we've talked about most of these by just going through the list here. It acts like a will, but it can own assets. Liz just hit that third one. You have to make the change on the titling to the name of, we'll say the Liz David Trust, Margie Cosmo Trust, etc. Titles must be changed from your individual name to the trust, kind of goes hand in hand with that one above it. And it can make, and that's everything that we're talking about, is trying to help to make settling your affairs easier upon death, but also, if incapacitation were to occur. So what happens if you're named as a trustee? I am a trustee on my parents' assets. So there's certain responsibilities that go with this. I think the slide here, that's a brother and sister. He's in the lead, looks older, so we're going to assume that the kayaker in the front was named as the executor. So let's look at a couple scenarios here. Okay, so the surviving parent is incapacitated. A lot of news, certainly in the last couple of days, surrounding Alzheimer's. It touches most families in some form or another. Anyway, I don't want to segue too much, but there's some hopeful pharmaceutical answers to that, hopefully coming about. So you have a parent who, whether they're living at home or maybe in a retirement community, nursing home, whatever, you have to oversee the health care of that person, understanding their insurance benefits, what they have, what they don't have. Medicare, as we all know, can be very complex. If there's minors, heaven forbid that that person that you named as a trustee on their trust has minors, then there's that responsibility to make sure that they're taken care of. Applying for disability benefits, if disability was part of the reason. I think there should be another bullet on here on long-term care benefits. And that's what we've seen here at Blue Heron Financial Group, is that trustee / power of attorney has to take over, and the long-term care benefits, that there's a lot of orchestration that goes on there. Notifying the bank or other financial institutions such as ourselves. Transacting business. If mom still lives at home, even though she has a caretaker coming in, there's still bills to be paid. And keeping accurate records and accounting. We touched on it before, but families, money, death can get, friction comes up from time to time. So the more accurate those records and accounting, the availability is very important. So what happens if there is then the death of the surviving parent? Well, first thing, we're hoping that you are working with an attorney and you can contact, and then that person, that attorney, can become the quarterback and help you facilitate those documents that were, again, hopefully put in place. Letting the other beneficiaries know communication is key. It's one of our Blue Heron sayings around here. Communication is key, as opposed to keeping beneficiaries in the dark. We do hear it sometimes when there is an inheritance situation and our client may be inheriting assets and they say, well, I really don't know what's coming to me. My brother's handling it and he hasn't returned my phone call for 3 weeks. So that communication can help to avoid that friction we're talking about. But again, if you're that trustee,
sorry,
yes, all good.
It can also help the communication, it can also help people make decisions from a tax standpoint. So again, if you are the executor and let's say there's an IRA involved, and let's say there's 3 beneficiaries, those 3 beneficiaries have to make different decisions on how to receive that money based on their own personal situation and taxes. You can't just check the box and say, send everybody the money, because that could be a big tax burden to them. So that's where the communication and having professionals involved is so important.
Yeah, very, very, very good point. And distributions, perhaps they can be made out of an estate account, but maybe there's a reason to hold back assets. Maybe there's, taxes that are due or bills that need to be paid. And of course, you're taking care of all of that, and then eventually distributing all the assets as the trust directs. So yeah, it can be a lot. And this is not something that people do every single day. And if you go to the next slide, Liz, please, then this, you don't have to go it alone. It's very important. So bringing into the equation the financial advisors and the attorney and the accountant. Liz brought it up before, but there's tax impact in some cases, in other cases not. So understanding what that may be.
And again, I think that this is where having a team approach, hopefully without sounding boastful, and there's a lot of you on this call we've worked with for years, and we are very close, and we want to be a trusted resource. Sometimes we run into attorneys who may not really pay attention to the tax implication of how money passes on. They just look at, the overall situation. They may not look at the fact that the IRA would be taxable and the Roth would not. So having the financial advisor, the accountant, and the attorney, when you're looking for an attorney, finding somebody that you trust and that you feel like understands you, I think is really important. Somebody that's going to be there through the long haul to help your executor work through all of this is important too. So bottom line, get your estate plan in order. We have a really good follow-up booklet that we will send out, just kind of outlines everything we talked about. Margie's being Vanna for us.
I am being Vanna. Yeah.
this is basically our disclaimer. Again, I think we've said it 10 times, but we are not estate planning attorneys, but it is really important in our opinion to really walk through this information and just give, you know, get you thinking, and hopefully a call to action that you think about this stuff, start having the conversation, start working on getting this stuff in place. You know, we're here as a resource. You know, we really appreciate you taking almost an hour out of your day. We went a little bit over time, but thank you all so much. We're here if you have any questions.
Thanks, everybody, for attending.